Welcome to everybody. Thank you for joining. I think I saw we had a really, really good registration list for this, and it seems like we have lots of folks joining. You can introduce yourself in the chat if you want. It'd be great to know where you're coming from and all of that. And I see some of that has started already. So I'm going to just get us going here. I am Dave Hansen. I am Executive Director of the Authors Alliance. And I'm just going to give some introductory remarks for this session that we're going to do today that Authors Alliance is really, really pleased to co-sponsor with Spark today on legal pathways to open access. And we're going to be focusing on federal public access policies, its legal foundation, and institutional IP policies. And I thought I'd just give a few sort of framing remarks at the beginning of this and then hand it over to our speakers who will really get into some weeds, but important weeds. And then we're going to leave lots of time for questions. I find that this kind of discussion always generates lots and lots of questions, and I can't promise we can answer all of them, but sometimes it's just helpful to hear that there are questions and that other people have the same ones. You can put your questions in as we go along. I think we're going to try to sort of hold them for the end. And we have the Q&A feature on. If you click the little more button, I think at the bottom, you'll find the Q&A question mark thing. And you can put them in there. It just makes it a little easier for us to keep track. But of course, feel free to also discuss and talk through things in the chat. That's what that's there for. So I just wanted to give, as I said, a few framing remarks before we got into this too deeply, to give you a high level overview of like, why are we talking about the law and public access policies? And I've encountered this a lot. I talk with lots of people about open access, and they wonder like, why in the world are lawyers involved at all here? Like, don't you just slap a Creative Commons license on things and then it's all open and we can kind of go along our way? And there's a version of open access that is sometimes legally pretty simple, and you can do basically that. But for a lot of works, there are an awful lot of entanglements, or at least questions about entanglements that cause us to pause a little bit before we just run ahead into full open access for those works of scholarship. And one of the places where the law and policy has become a little bit complicated, and there are lots of questions right now, is when it comes to works that are subject to federal grant requirements that they become immediately available under public access policies. And we've started to see these roll out. I'm sure many of you are familiar with them, and Carly will talk a little bit about some of this stuff. But that's kind of the crux of the issue, is that we've got some special requirements and some special legal things going on when it comes to federal grant funded works. And so actually a couple of years ago, I guess it was now, me and Heather Joseph, who's on the call here, I think, we're talking through how like this is a pretty complex area, and we're seeing lots of questions, both from authors, from librarians, from folks in research administration about how to navigate this space. And there were lots of unresolved questions, which was a little bit fascinating to me, because although some of the policy around public access to federally funded works was changing, like we were expanding it to other federal agencies, and also shortening the embargo to zero embargo, the underlying legal issues honestly weren't really that different. And so it was sort of perplexing to me that we hadn't like solved all of this stuff yet and had very clear answers. Well, a couple years later, it's much clearer to me why we don't have totally clear answers to all of these. Lots of that thanks in part to the good research work that Eric Harbison has done on trying to kind of disentangle federal policy, grant requirements, and administrative law kind of stuff, and institutional IP policy, and how all of that squares together with copyright law. So Authors Alliance has put out a series of papers on a number of different legal issues here. We're going to focus today especially on kind of how these things interact with copyright law and institutional intellectual property and copyright policies. But the papers are, I think, give a really helpful legal foundation for how all of this works. So I'm just going to put a link in here And we have a resource thing at the end of our slides as well. But basically, these papers run through kind of the foundational thing of what mechanism is it that allows the federal government to say, hey, when we fund your work, that thing has to be made available. What is the legal mechanism that allows them to do that? Many of you have heard of the federal purpose license or the government use license. That's kind of the starting point for a lot of this. But then there are also lots of other questions. For instance, not just what is that basis, where does it come from, but is this legal to begin with? That was sort of the second paper that Eric wrote, addressing things like, is this constitutional, and how does this interact with things like free speech or government takings, those sort of questions. Which that paper was actually a joy to read to me, because it was all like, not a problem, not a problem, not a problem. It was pretty straightforward. But then we get to two other papers. The one that Eric's going to really, I think, get into the most here today, which is how do federal grants and institutional IP policies fit together? And crucially, like, who actually owns copyrighted works created by scholars when they are first produced? And then the last paper is one that our colleague Yunxiao Xu wrote on thinking about public access policies and the different kind of versionings of articles that we have along the way, and how the interaction between author, institution, and journal affects rights in those works, and downstream use. So I encourage you to check them all out. We tried to write them in a way where they would be useful to, like, your lawyers, your Office of General Counsel. They could have lots of citations, and they could look at the case law, but they'd also be useful for other people to really engage in the content. So that's my introduction. And you can see on your screen spotlighted here the other three speakers: Carly Robinson from Spark, and Enriquez from Penn State, and Eric Harbison from Authors Alliance. I will give no further elaborate introduction to them. They are all eminently qualified. If you do some Google searches while you're listening, you'll find like pages and pages of awesome stuff that they have done. So I'm just going to turn it over to them, and Carly is going to start us off. So thank you all.
Thanks so much, Dave. Really appreciate it. And if you want to go to the next slide, Eric. So at this point, I think you all are very familiar with the 2022 OSTP memo. So I'm not going to go into detail. You've probably heard me do that a few times before. But I just want to hit on kind of the top line areas on what we'll be discussing today. So the memo directs agencies to develop policies that provide access to peer-reviewed scholarly publications without any embargo after they're published. So at this point, there are 19 federal agencies that now have those requirements in place. And that includes some of the largest extramural funders. So NIH, NSF, DOE, NASA. You can see all of the logos there of the 19 agencies that have these policies in place. And all of those agencies require the author accepted manuscript to be submitted to the agency designated repository, either upon acceptance or by the publication date. So that way the agency can make them immediately available. There were a number of questions because, of course, this memo came out under the last administration. So when the new administration came in, there were a lot of questions about, would this still be implemented fully at agencies? And, all indications we've gotten is that this administration is still supportive, and they have kind of said that it especially supports their efforts around gold standard science. Now, as I think many of you have experienced, there are some things that kind of cause some questions around implementation of these policies. And that particularly comes with the fact that the institution is the grantee and they are signing the award agreement or the contract with the agency. But when it comes to publications, it's the PI, the author, that is publishing the manuscripts and is left to help kind of comply with the expectations of these federal agencies. And they're the ones navigating not only how to comply with the funder policies, but also journal publisher policies and trying to figure out how those fit together. I will say, the journal publisher policies are not always the easiest to navigate. And, I think there are a lot of questions and sometimes authors don't even realize that they need to be thinking about these things. So if we go to the next slide, this is where I wanted to hit on a little bit more. Dave already mentioned the federal purpose or government use license, but I think it's helpful to always kind of refer back to the very specific language. And this language is included in the terms and conditions of awards that the institutions agree to when they accept federal funding from the agencies. And so I just want to kind of mention the part that is highlighted. And so this is, really key. It's that the agency reserves a royalty-free, non-exclusive, irrevocable right to reproduce, publish, or otherwise use the works for federal purposes and authorize others to do so. And then that last sentence was added a couple years back. And this was to kind of explicitly make it clear that this includes the right to require recipients and subrecipients to make such works available through these agency designated public access repositories. So this gives the agency a license to the works, prior to researchers, say, signing any agreements with their publishers. But that's kind of a tension that we'll be talking more about today. I do want to make one note because, of course, OMB has proposed updates to 2 CFR, and this language does come from 2 CFR 200. And just want to note that although OMB has proposed many, many updates to 2 CFR, they did not propose any updates to this section. So no matter kind of what happens moving forward, this federal purpose license language is not going to change, and that kind of signals this administration's support. So I will stop there and hand it over to Eric.
Sorry, I was figuring out how to get myself unmuted here. So thanks, Carly. I'm really excited to be presenting on this because this is honestly one of my favorite papers that I've ever written. And it's one of my favorites because it's very much about the journey. It's 30 pages of why this is a problem, and then basically the short answer to the everything is just get it in writing. I mean, that's kind of the 30 pages of getting to why you just need to get it in writing. And what you need to get in writing is part of the issue here. But I wanted to, so what I'm talking about in this in my portion is Carly mentioned it's the institution that does the signing of the grants, but it's the researcher, the individual researcher that does the research and does the publication. And of course, it's not just a lot of times one researcher. In some cases, it's several dozen or even several thousand in the case of one article I found, researchers. And who is the author among all of these thousands of researchers is not something I'm going to get to. For the time being, we're going to assume that there's one researcher and one institution and one publisher, and then there's the federal government. So we're starting with the author, and who the author is the central question here. But what the author is easier. The author is the person or persons or entity in whom copyright vests automatically. That's the best definition that you're going to get out of the Copyright Act, is the author is that who gets the automatic copyright. And the author controls at the outset what we say the ab initio rights. They control all of the exclusive rights at the moment that the work is created, and they may transfer some or all of those exclusive rights And they also may grant those rights prospectively. You can agree to sign over rights in advance of a work's creation if you're the author, but only if you're the author. Um, so the two kinds of licenses that are interacting here is there's the exclusive license and there's the non-exclusive license. And the exclusive license is it's exactly the same as owning a given use or owning a given right. There's in the Copyright Act, there's no difference between exclusive rights, an exclusive license, and a transfer of copyright ownership. So if you have an exclusive right, if you have ownership, they're the same thing. And what they mean is you can exclude someone else from making that use. That's why it's exclusive. You can exclude someone. A non-exclusive license is one that doesn't include the right to exclude. So what that allows is you can transfer one exclusive right. You can transfer the exclusive right once, and then you don't have it anymore. But you can award non-exclusive licenses by the thousands or hundreds of thousands or millions in the case of software. And so but each of those people who receives the non-exclusive license has no right to exclude others from making use of it. So you start with the author, and the author has all of the exclusive rights. And what we're contemplating here is at some point, the author wants to publish this work, and so they transfer the copyright ownership to a publisher. So you see you have the author has all of the exclusive rights until the moment they transfer those exclusive rights to the publisher, and then the publisher has the exclusive rights. Now, when you have exclusive rights, you have the right to grant non-exclusive licenses. So everyone can grant non-exclusive licenses. But you can only transfer all of the non-exclusive licenses have to grow out of an exclusive right. And so this one exclusive license here is invalid because the author doesn't have that exclusive right anymore. You can only you can only make non-exclusive licenses during the time when you own exclusive rights. And one thing I didn't include in this graphic here is that non-exclusive rights can grow out of non-exclusive licenses if they are transferable, and that becomes important here. So, but what happens after the transfer of ownership? Well, the non-exclusive licenses that the author, in this case, granted, survive that transfer. So the non-exclusive rights continue, the non-exclusive licenses continue even after you've transferred exclusive rights. And they last for as long as the non-exclusive license is allowed to last. So in the one case in my graphic here, I have one non-exclusive license that had an end date, and so it expires. But then the other one is perpetual, and that one keeps going. So in a non-exclusive license prevails over a conflicting transfer of copyright ownership if the license is evidenced by a written instrument signed by the owner of the rights licensed. And that written instrument is what's important. If you have that written instrument, then the grant agreement serves as it includes the federal purpose license that Carly mentioned. The grant agreement is a written instrument. The grant agreement is signed, and so the government has its non-exclusive license. So the government is happy. The problem is, as we alluded to, who is the author? The author is the author. There are two possibilities for who is the author of something that's produced by this by a grant. Now this is from this is language from the Copyright Act. In the case of a work made for hire, the employer, et cetera, is the author for purposes of this title. So if you are employed and you're doing something within the scope of your employment, then that something that you just did is not actually authored by you for purposes of your employment. It's authored by the institution. This paper that I'm talking about was written in the scope of my employment at Authors Alliance. So I'm actually not the author of that paper. Authors Alliance is. And so this is a thing that comes up often, and we don't necessarily, like, I definitely assume that I wrote this paper, but in fact, legally, Authors Alliance owns this paper, so I suppose I should be getting permission from Dave to do this, which I assume I have. Anyway, a work made for hire, there are two definitions of work made for hire. We're mostly concerned with the first. A work made for hire is a work that's prepared by an employee within the scope of his or her employment. And the second definition is specially ordered works or commissioned works in 9 classes of work. So if you specially commission something as an audiovisual work, that can be a work made for hire if you have a written instrument signed by the parties. And again, you have this signed writing requirement. And this is my graphic for how to figure out whether something is a work made for hire under the leading case on the topic. The important thing to realize here is that under this first prong, which is what we're concerned with, the determination, is it an employee, is the person an employee, and was it created with in the scope of their employment? That's the extent of the definition. You don't have anything more to go on from the statute. And so the courts determine this based on the common law principles of agency that they've developed over several years, decades. And the problem comes from this is the problem that's created. If you have an academic work that is made for hire, and the institution is the copyright holder, they're the author, they can assign the non-exclusive license to the government, and the government is happy and everything is fine there. But the problem is that then the author, the individual researcher comes along and says, well, I want to publish this in XY journal, and the publishing agreement says you transfer exclusive rights in this work to the publisher. But if the researcher is not the author for legal purposes, then how does the author, sorry, I keep having to correct myself, how does the researcher get the rights to transfer the exclusive rights? Because you can only transfer exclusive rights if you have exclusive rights. And so both of those contracts potentially fail. And then the flip side of that is, supposing the researcher is the author, and this is more controversial because under like a straightforward reading of the work made for hire definition, you would assume as a faculty member at a university that you are an employee. And perhaps you would even assume that writing this research is within the scope of your employment. And so like a straightforward base level reading, perhaps this isn't a situation that you need to consider, but what I found in researching this paper is that it is actually very uncertain whether the faculty member is an employee for purposes of scholarly research, or in the alternative, if the faculty member is an employee, but there is some kind of court-made exception to the rule. And if that's the case, if for some reason the academic works are not made for hire, then you have the same problem, only in reverse. The author, in this case, is the researcher who has all of the exclusive rights and can transfer exclusive rights to the publisher, and then the publisher is happy. But the university has signed this grant agreement granting the non-exclusive license to the government. But where does that come from? Again, you can't grant a non-exclusive license unless you have that right to give. If the university doesn't have that non-exclusive license, they can't grant it to the government. So what does that leave you? Get it in writing, and get it in writing in advance. And specifically, what you have to get in writing is you have to get for the institution has to, prior to the creation of the work, get a written non-exclusive license that allows it to transfer it to the agency. On the other hand, if it turns out that the faculty member is doing this as a work made for hire, then the faculty member needs exclusive rights in order to publish the work. So you need signed writings in both directions. There needs to be a signed writing sending the exclusive rights to the employee, and a signed writing sending a non-exclusive rights to the institution. And then everyone is happy. And so now I turn it over to Anna.
All right. So playing off of a question that's just come up in the chat, or a statement in the chat about university IP policies, that's something that's addressed a lot in Eric's paper. And if you haven't read Eric's paper, or at least looked at the headings in Eric's paper, I highly encourage it. It's a great paper. But one of the things that he talks about is, how can we look at our own institution's policies to figure out whether they achieve what we might hope for? So some places you might look, there might be an overarching policy on IP or copyright. I think most universities have one of those. And then there can be other policies that interact with that. So employment agreements, or maybe even specific IP agreements signed by employees at the time that they join the institution. Perhaps also things signed by PIs when they start a grant. But keep in mind that authors of papers that might be covered by public access policies aren't exclusively PIs. They could be a lot of other people. They might be people who aren't affiliated even with the university at the time when the grant is accepted. You could also look at an institutional open access policy. A lot of us working in libraries and attending Spark events know those policies pretty well. And they tend to give you clues about how the rest of your institutional policies are structured. Research data management policy, if you have one, would be another place to look. And then also collective bargaining agreements, if your university has one that covers researchers. And this is probably not surprising to anyone, but potential helpers in your search for university policy or your university's approach to these questions would include the Office of General Counsel, the Office of Research, and the Office of Technology Transfer. On my next slide, I have a little bit about the flavors of institutional IP policy. And this graphic is taken from Eric's paper. So Eric characterizes three possible futures. Basically, we don't know what the law is in this area. We have three possibilities of what it is, and some of those are probably more likely than other possibilities. But for any given funded publication, publication arising from a grant, it's hard to predict who the author is under copyright law. And most institutions actually take a position on this question. And they say, for most of the articles at Penn State, they are works for hire. And then the university grants the rights back to the researcher, and the researcher can sign the publishing agreement. But at my institution at Penn State, university policy assumes that we are in future number one. The university policy at Harvard, last I checked, assumes that we are in future number two. That this teacher exception that Eric was talking about is valid and would apply to faculty scholarship there. And so the author would be the institution, except that the teacher exception comes into play, and so it's the creator. And Duke is maybe in that category, or maybe operating in future number three. It's a bit hard to tell. But saying that none of this is works for hire, including things not by faculty. That's to my reading of it from outside of Duke. And all of those institutions that I've mentioned, and probably your institution as well, have based their policies around their assumptions about what the law is going to turn out to be. And for me, this is the key insight of Eric's paper, is that that is not the right approach. We should instead account for the uncertainty. You know, it's fine for the institution to have a position on this question. That's great. But the institution doesn't actually get to decide what federal law is. The institution needs to prepare for all of the possibilities. And that's where the get it in writing recommendation comes in, where you want to get it in writing from a transfer from the institution to the researcher, retaining rights as needed, and then also a non-exclusive license from the researcher to the university. And if you do both those things, then you've covered your bases. I don't think there are many places that are getting this fully correct right now. But hopefully these two slides have given you a sense of where you could look to figure out what your institution could do to improve its own position. And then over to Dave for the next slide. I think we're into our pre-submitted questions.
Thanks. That was fantastic. Thank you all for those great presentations. So when we put out the registration link, we had the opportunity for people to pre-submit some questions, which is really helpful because we get to think about them. So we're just going to put some of these up on the slides, and I'll just read off the question. And Carly, Anna, Eric, just jump in with any responses that you have. We have some obviously listed here on the slide, but question is about whether you can provide tips for how to share legal pathways with researchers while steering clear of language that could imply that librarians are giving legal advice.
I can start out on this one. I always recommend, if you're worried about giving legal advice, a great thing to do is to share published materials. So Spark has a guide for authors complying with federal and publisher policies. So if you were working with researchers in this area, that would be my top recommendation. Another thing that I've done is write my own FAQs or workshops based on the questions I'm getting or I know I'm going to get, but a little bit less personalized so that people don't get the sense that I'm their lawyer and I'm giving them advice about their particular situation. Because that's one of the things you really want to avoid is giving your library patrons the sense that you're looking out for them when in fact you're a librarian, you're providing information, and ultimately your duties are to the institution. And then also working with colleagues from other parts of the university. Sometimes you can get the university to take an official position or, get the vice president for research to make an official statement. And that can be really helpful. But again, it's not going to be legal advice. It's going to be like the university's position.
I will add, this sounds a little snide, but I've started off an awful lot of emails saying, I am not your lawyer and I can't give you legal advice. And sometimes that feels a little awkward, but it sure deals with that problem of implying that you're giving advice, legal advice, when you don't mean to. So, and I've never had someone respond to that negatively. So I think that's a good little addition. Next slide. Will researchers be breaching their publishing contracts if they rely on the federal purpose license? I'm going to let someone else figure this out.
I can start out with this. It's a really tough position for the researcher because it's not none of this language was designed with researchers in mind. In the case, the federal purpose license comes from the Code of Federal Regulations, like Carly mentioned. That language is there for the government to claim the license for the government. And then the university grants the license to the government, and the researcher kind of isn't part of that. Now, if the so basically the relying on the federal purpose license is not something that will help the researcher in uh, in publication agreements when something contradicts that publication agreement. It will help the government to publish the work. It will help the government have the license, assuming that the license is valid. But it's not something. It's not a license to the researcher. It's a license to the government. At least that's where I would start. Anna is being contemplative, at which point I've learned to listen to Anna.
Well, the reason I was looking contemplative at that is I, it's true that the federal purpose license is a license to the government, but it's also sublicensable. And when they tell a grantee to deposit something in the institution, in the funder designated repository, I think that they're authorizing you to exercise the rights that they have, or at least there's an argument for that.
Mm-hmm.
And the other thing I would throw in on this question is just what we've got on the second bullet, which is that at this point, publishers definitely know about these policies. Many of them have formally reacted to them. And if they are presenting contracts that conflict with the federal purpose license, that's actually something they shouldn't be doing. And so it's not all on the researcher to notice and interpret provisions of their publishing agreement, which might basically be like magic words to them, right? They might not understand the significance of some of this language. It is at least equally on the publisher that's drafting the agreement and presenting it to people without the ability to negotiate often. So that's my 2 cents. And also, at the moment, it doesn't seem like publishers are. I'm not aware of a publisher bringing a breach of contract claim against a researcher over this. And I think that's in the guide to authors, right? Right, Carly?
Yeah, and just to add on to that, kind of what we've heard from you all who are hearing from authors more directly than we at Spark are, and that's how we help develop the guidance. So really appreciate all of you who contributed to that. But what we have heard is that kind of the most we've seen from publishers going after authors in some way when they deposit and they've maybe signed something that transfers the exclusive right is to send a bill to the author saying, okay, you did this, now we're requesting that you pay a fee. And that so far, and I'd love to hear if there are more, but we've heard only of that happening from ACS so far. So that's what we've heard. Now, then I think it's an open question of what happens if an author then chooses not to pay. We haven't heard about kind of what happens next, but that's kind of everything that we've heard right now. And it also, this is asking about the researchers, the authors, which I think is the right question, because we haven't seen any indication that the publishers would go after the government agencies in any way at this point.
One of the other things that I think is important to emphasize here, I've seen this a lot. One of the things that I've noticed is there is, if you go to like Wiley and Elsevier, you'll find statements that really try to direct authors into paying APCs for open access fees. When you go and actually read the contracts themselves, it gets a little bit more gray. I'm not saying that those contracts, the publishing contracts, allow it, but there's at least a little bit more room there to kind of make some arguments about what you're allowed and not allowed to do. And I guess the main point I'm trying to get across here is uh, those contracts, the terms of the contracts are what control, not the FAQ sites and the other kind of material that the publishers put on their websites. Almost all of those contracts have a clause that says, this contract is the only thing that governs, and other stuff outside of this contract is not going to kind of affect the rights that are granted herein. So read the contracts really closely. I find a lot of people get really kind of caught up in the FAQs and the, author info pages, and those can be helpful, but they're not going to determine whether you lose or win on a breach of contract claim.
I think the thing to remember, if I could,
sure,
is that, so back, since I'm controlling the slides, I'm going to go back to here, because if you like, if we, even if the institution and everyone gets all of the agreements in writing between the institution and the researcher, that would put a green check mark. That would mean that the author the researcher now has the rights to transfer to the publisher, but you're still only like the exclusive rights that the researcher can transfer to the publisher are limited to what they have in hand right now, which is in this case a an article that has, let's say, an article that has a couple of prior non-exclusive licenses attached to it. The author, the researcher can't say, I can't transfer exclusive rights as though it were back here when she had all of the exclusive rights. As soon as there's a non-exclusive license that attaches, that does survive. And as a result, what happens at the transfer of ownership includes the transfer of those non-exclusive licenses. So it just, I don't know if that helps at all, but I find it's one of the things that that questions like this risk misinterpreting is what the researcher is engaged with the publisher on rights, but the researcher has already granted rights and can't just take those back because the publisher agreement says they do.
Is it necessary to attach an author's addendum to a publication agreement if rights are already reserved by both the federal purpose license and the institutional policies? This is a really interesting one. I'd love your take, all three of you, on this.
I think it's not necessary. It might be useful to certain authors depending on, the situation with a particular publisher. I think not with the publishers that are using the more click-through kind of author experience, author journey platforms. NIH has also provided the rights retention language that you can put in your manuscript. So if you're concerned about communicating to your publisher about this, the addendum could be useful for that. But it doesn't help make the federal purpose license stronger, because to do that, what you want is the federal purpose license is already pretty strong, but you want
Right.
to dot your I's and cross your T's on the institutional side. So I don't think the addendum makes much of a difference in this context.
I agree with that. I think it's a helpful communication tool, maybe, but it's not legally doing anything. Let's go to the next slide, and this is maybe a good one to end on here. How should libraries be communicating this information?
maybe I can start. And honestly, this is just hitting a lot on some things that Anna had already talked about. So this is and this is what we've been hearing from you all too. That can be tremendously helpful. So regular communication with researchers and authors in many different formats. So whether it's developing your own resources, pointing to other resources, giving presentations in different formats, whether that's onboarding for uh, new employees, annual refreshers, if that's kind of something that's on your campus, for grad students doing it during orientation, and then also as was already mentioned, partnering with campus offices to share this through different fora and to to kind of work together and have kind of mutual support across campus. And so, sharing the same message, having the same expectations. And then, if you, as you have these campus policies, understanding kind of who owns them or who has leadership from them, and asking questions, working with those groups. So I think I'm just reiterating a lot of things that was already shared. And then on the next slide, we also point to some resources that were mentioned that might be of use. So of course, the white papers, the guide for authors, but there's other resources. So Authors Alliance, NIH Public Access Policy question and answer for authors. We do have a resource that's kind of higher level core elements for the policies if you want to kind of have a quicker look. And then there's so many incredible LibGuides. Thank you for adding this one from Penn State, which is really wonderful there, but also know a lot of you have created great other ones. So highly recommend pointing to those as well.
All right, we are at time. There are always lots and lots of questions that come up with this, and I never have quite all the answers. But I think this last one is a really good place to end. The problem I really have with so many authors is that by the time they get to me and they realize it's a problem, there's only so much any of us can do. They've signed something already and they're kind of in the hole. And so I really encourage you to like try to get out in front of that and get in front of people as early as possible. But I know that's hard. Thank you all for being part of this and all the great questions. They were really, really wonderful. We did record but we will trim off the Q&A portion so that everybody's questions aren't recorded for posterity. We'll trim that off and then it will be shared. And yeah, and thank you to Eric and to Anna and to Carly. This was a lot of fun. It was great to hear from you. And I hope we get to do more of these. These are a lot of fun for us. Okay, take care, everyone.